Good evening all. Welcome to today's session. A pleasure to welcome you all to this special session organized by Make USA, Middle East Quantity Survey Association, which is located in Qatar. Last time we had a free webinar, number 19, and EOT on the FIDIC 1999. And many of you have requested to do something like notices. Based on that, today we are going to present notices under FIDIC 1999. First of all, I'm glad to see many of you have interested to join. We receive plenty of requests as well as registration. I hope all of them will join without missing the session. Let's give a couple of minutes for others to join. So I think we have it's almost 7:30. So without further delay, let's start our session. Many of us we are aware that most of the time we do use contract for the purpose of managing the parties. Of course, we are aware that contract's going to be the final document which is going to come back as well as overrule all the problems that we are going to identify or we are going to raise as a dispute at the end of the projects. Of course, we are well aware that the contract is the final document. In the contract, of course, mostly they do mention many things, not only one or two information. Of course, they do list hundreds of thousands of information. They do ask us to follow those things. And not only within the contract, but also they do attach many documents as appendices to the contract and ask the contractor or other parties or the parties to follow them. It's very common. Of course, you can see in KSA or Dubai or Qatar, mostly they use their own fabricated, or I would say the tailored contract that they use for the purpose of development. Mostly, if it is a client, well-known client or real estate developers, or maybe someone else who can do a big jobs or big projects, they do have their own projects, own contract, as well as own document, which is going to tell them, or which is going to direct the contractors or the parties what they're going to do. But most of the contract, if you go and check them, of course, that may be with hundreds of clauses, but most of them, they do develop based on one of the existing standard form or standard form of contract. So normally, within the GCC region, of course, you can say that they use FIDIC as a well-standard condition of contract, and they do make whatever the changes they want for their project and use them for the purpose of completing the projects without any failure. The main reason of using standard form of contract, we all know that one, which is readily available. Of course, you don't want to spend time and cost in order to develop one to you, as well as, that's already incorporated hundreds of problems and solution within that. When you are going to develop one of your own condition of contract, it may make a problem to you in terms of dispute. So because of that one, they do take one of the standard form of contract and they do make whatever the small changes that required for their projects, and they do execute that as their contract. But almost, if you have a knowledge, if you have a good knowledge from FIDIC, of course, you can manage your contract, because, as I said earlier, they have developed this contract based on mostly FIDIC. Of course, you can see that most of the contract they do develop based on 87 or 1999. In that perspective, 99 is the one which is being used almost all the GCC region as a bespoke or standard form of contract. So in that perspective, today we are going to learn about what kind of information or what are the clauses giving explanation in terms of notices, because notices are one of the important things that we need to watch out. They are with a time frame. Mostly, if you miss that, of course, most of the countries or most of the places, you are not able to recover your entitlement. So you need to watch out that, and you should have a clear information as well as understanding on that. Then only you can you can successfully complete your notice as well as subsequent or consequent procedure from there. So we are going to check today what are the contractual formalities for a notice FIDIC 1999 say, as well as if you fail to follow the formalities, not the time bar, if you fail to follow or fail to comply with the formalities of notices, what are the consequences will be there, and what is the importance of notices, and time frame for notices, and what it says, what are the method that it is saying that time frame for your contract, and issuing notices, whom you need to issue, how you need to copy that, and what you should include within the notice, and what kind of impact that you will incur if you fail to deliver a notice within the time bar. So these are the things that we are going to learn today, especially. This will help you in terms of implementing or practicing your projects, or in order to answer some kind of interview questions, or maybe RICS APC questions that will help you to overcome those kind of situations. So very first thing that we are going to learn about content or contractual formalities of notices. Of course, in the FIDIC 1999, there are a couple of clauses which is telling you what is notices and how it should be, and what are the information that you need to incorporate, and what kind of situation that you can use. Of course, top of all, we should know that communication is one of the basic requirements for any projects. Why? Because communication is the one which is going to transfer any of your information to other parties. Whoever involved with the projects, you are going to inform them certain information or certain problems or certain decision or anything that you want, you are going to communicate to them. If you are going to communicate that in a proper manner, and if your project have a very good protocols or communication strategy, then you will find a very good guys, can you all see the presentation? Someone said they cannot see. Can you please type whether yes or no? Yes. Okay. So Lakshit, I think maybe it's maybe your internet. So please check it. Some of you, if you can't see, I think it's maybe because of internet problems. I'm not sure. Yeah, many of you can see. Okay. Okay. Otherwise, you need to log out and log in, please. Please log out and log in so you will get it. So the very important reason that we need some sort of formalities in terms of issuing notices is because to keep aware other parties in terms of information. Of course, these communications must be in writings. Of course, our FIDIC 1999 says that under clause 1.3, yes, 1.3, it says very clearly that you can issue or you need to communicate with other party for the purpose of approvals, certificates, any consent, determinations, notices, and requests. So FIDIC very clearly saying these are the situations that you can start and make your communication. It means that simply this is going to cover everything that you are going to do, especially approvals from the engineer or the employer to you, or the certificates from them to you, consent from them to you, determination from them to you, notices from you to the employer or maybe engineer to you, as well as request from employer or the engineer to you or from you to them. So it's going to cover all the networks as well as all the protocols, which is going to tell you how your documents as well as communication should be. So simply under clause 1.3, FIDIC very clearly says how and what are the information that you need to make a communication. As a continuation to that, under clause 1.4, the contract says, FIDIC says that how your communication should be. If you are going to communicate something to them, if you are going to communicate something to them, it can be handwritten, Of course, you can write by hand and send that to them. And that can be by typed one, or maybe printed or electronically made, as well as a permanent document. So anything that you can use. But normally, when they want to use this kind of FIDIC, standard form of contract, what they do remove some sort of information which they think that it is not appropriate for the contract. Of course, sometimes they do remove everything, and they mention that only your communication should be through handwritten or typed or electronic. So if you are going to do some sort of contract, and if you are in charge, or if your employer is asking you some sort of advice, what you need to do is you need to make sure that under this clause, you are making enough changes to incorporate all the documents and documents how it should be. All the document and how those documents should be submitted to you. Otherwise, if the contractor identify that they cannot submit certain form of the document to you, then that will be a problem. Again, then you need to go and amend your document. So at very first instant, before you issue your ITT with all your documents, volumes and everything to the contractor, you need to make sure that you are going to make sure that you are incorporating all the document within that. And the next one, FIDIC says about how and what kind of medium that you can use. Of course, most of the time that they are telling that you can deliver the document by hand. Of course, if you are working in a contract, of course, very, very rare that you receive document through hand, because mostly we do receive them through electronical medium, something like, PM Web or Econex or some sort of electronical connections or communications resources that we are using to transfer. But normally within the contract, the employer, they may change this kind of understanding, or they will keep it and they will ask you to incorporate or practice whatever the possible method. Of course, in the FIDIC says very clearly that you can deliver your communications, whatever it is, notice, consent, determination, whatever it is, you can deliver that to the other party by hand, or you can send by mail or courier and electronic transmission or any other things. Make sure, guys, within this, you need to make sure that if you are going to use emails as an evidence, or maybe a official communication, you need to include email within that. They are very clearly mentioning mail or courier or transmitted using any of the agreed system of electronical transmission. So in order to agree that electronical medium, you need to mention that within this clause, you need to mention that you are going to use email also as a medium. Otherwise, you need to use here appendix to make all your changes. Okay, you need to use here appendix to make all your changes, or particular condition that to make any changes. So whatever the medium that you are going to use as an evidence or official communication, you need to mention that. If you are going to simply mention that all the electronical medium going to be considered as a delivery method, that's fine, but you need to give some sort of explanation. Of course, mainly the contractors will come back through post-tender clarification, and they will ask you, okay, you have commonly mentioned media as electronical media, what kind of media that we can use? Of course, I have one media which may not suitable for you, or you are not familiar with that. So most of the time, the employer, they will mention this is our electronical communications media, maybe a Connect or PM Web or whatever it is. So you need to mention that within that time. And the next one is, if you are going to issue notices, FIDIC says that, of course, under 4.2F, it is say that 4.21F, it says very clearly that you need to record all your communications notices, all your communicated notices as a list. It's a contractual requirement. You need to list all your notices within your monthly progress report. It is very important. You need to comply. You need to oblige. You are obliged to follow that procedure. Unless otherwise, your contract says no need to. So it's very important that you need to list down all your notices that you have issued to the employer, and when you have issued to them, and what is the status of that. So something like, registry or log of your notices, you need to incorporate under or within your progress report. The next one that we are going to learn about, what is the purpose of notice communication? The very important, very important, the main purpose of communication is to make sure that we are doing something transparently, and we are not going to keep some sort of very big issue in terms of cost, time, or anything, and we're going to bring that at the end of the projects and make uncomfort to the employee. Of course, you need to make a communication as early as possible in order to make or alert the parties that informing that I have so and so a problem. So the main purpose of communication is to alert the parties as well as make sure that we are doing transparent and reasonable, convenient, as well as capable of providing information. We are capable of providing information. We are doing reasonable steps. We are fair to do all those things, and we are giving an early alert to you to make a decision on that. This is the main purpose of communication. And the next one is saying about, should I mention under the contract, under the notices, I'm going to write one contract, one notice. Do I need to mention that I'm issuing this notice under so and so clauses? Under FIDIC, do I need to mention? Anyone? You can type your answers. Okay. Okay, so I can see no, yes, and everything. Of course, FIDIC generally they don't ask you to issue, mention notice under which clause you are issuing generally, except one clause. Except one clause. If you take FIDIC 1999, it says only under 20.4 that you don't agree with the DAB decision. DAB, Dispute Adjudication Board, they made a decision and you are not happy with that. So under that clause only, it says that you need to mention the clause. You need to mention I am issuing notice under clause 20.4 as I don't agree with the DAB decision. To refuse that. Only that situation is the one which is mentioned within the contract FIDIC that you need to issue or mention your notices. But it is not a common situation. We don't use FIDIC as it is. We do make a lot of changes. Of course, employer, they will mention mostly if you are going to issue notices under any clauses, you need to mention the clause under which clause you are claiming. But if you take standard form of contract, FIDIC, it doesn't ask you to mention the clause number under which clause that you are issuing except 20.4. 20.4 is related to rejections, or you are not accepting the DAB, Dispute Adjudications Board decision. Only on that situation that you need to mention. Other situation you don't want to mention. But as I said earlier, most of the time, the employers, they do change those things. They do change and they do mention. For example, I work for Bahrain Airport, where they have mentioned if you are going to issue notice under any clauses, you need to mention the clause. Something like subject notices under clause number so and so. So that is going to give a good information, as well as that will avoid whether the employee needs to take a decision, or the employer will be confused if you just issue without mentioning the notice number. You're just issuing it. So that will make it confused to the party who is going to receive that letter. Yeah, normally they will think, okay, they are just issuing that for the purpose of information. Or they may think that whether they are expecting us to do approval, or maybe they are expecting us to do some sort of determination, or whether they are telling that they are going to submit further documents. We may not be aware about that. So it's a best and good practice to make sure that we are going to mention the clause within the letter. We're going to see some sort of example letters, templates that we have used previously, so you can understand them. And within the contract, if I, for an example, let's say that I have mentioned that you need to issue the letter to a specific address. I mentioned notices should be directed to so and so person, and the address, it's going to be something like, the head office address or any other address it can be. Do you think that you need to issue letters or the document to that address? No. Even though within the FIDIC it says that that is the official communication, but it's not the practice we are following. Of course, we are directly directing the person who is working on behalf of the employer, and we are sending to the employer. Normally, the notices we do send to the employer and copy to the engineer. That's what most of the contract says. That's what most of the contract says. So you need to send that to employer and you need to copy to the engineer. There's no contract which says that you need to issue notices to the engineer. Why we are not going to issue notices to the engineer? Why we issue notices to the employer and the copy to the engineer? Because they are not the party to the contract. Notices normally it is for the purpose of making awareness or any other problem at early stage to make alert of them. So the party to the contract is employer and the contractor, not the engineer. Engineer is someone who is going to supervise us, or the PMC, they are going to manage us. So we are not going to issue notices to them. We are going to issue notices to them, to the employer, and we are going to copy to them. But the engineer can issue to us. We are going to see those things. So even though they do mention one of the address, normally we do issue those documents through electronical or to the person who is handling and send the copy or the original document to the party through emails or any other medium that are available for us. So it's not very common for us to send all the document directly to the address mentioned in that, unless otherwise your contract's very creepy one, which is saying that you need to send all your document through email, not email, through mail or courier to the address. There is a practical problem in that. For an example, if international contractor is going to come and work here, and their address, the head office address in, for an example, it's from France or Italy. Do you think that issuing letter or sending letter through courier will reach them within the days, within the time period that you expected? And that will make they are going to respond to you through email within the period that you have mentioned? That no, practically you will face a problem. That's why normally, even though they mention those address within the contract, we do make a communication through emails or someone else directly, unless otherwise your contract very specifically say that you need to send through courier. The next one is within the FIDIC, we have a certain obligation under two parties. Of course, there are two parties to the contract. One is contractor, another one is employer. In terms of employer, employer's representative, engineer or contract administrators, they also can act on behalf of them. So FIDIC says in total 58 places they are telling that the party should issue notices. Out of that 58, contractor can issue notices, or he should issue notices to other party or the employer, 33 places, 33 situations. And the contractor, they can receive notices, or the engineer and the employer will issue notices to other party through 19 places, or within 19 events, or by 19 events. In total, 58, including both parties, can issue notices for any situations, maybe cost, time, or any other consequences that you are going to face. You can issue notices. So FIDIC says in total 58. Out of 58, 33 by contractor, 19 by employer, or we can say engineer, and 6 by both parties. So this is the total number of notices that can be the situation that parties can raise notices. The next one that we are going to say, if I fail to follow these formalities that, I'm going to issue the document, I fail to issue the document through hand, written documents, or maybe to the parties address, relevant address, or maybe I did not make it in a proper format, or something like, these kind of formalities. I did not use proper paper, something like that. Are they going to make me a problem? Am I going to end up in a problems? Simply, no. In many countries, most of the countries, they don't check what is the medium that you have transferred or you have informed to them, but what is the information that you have informed to them. Very important. They will check what information have you transferred to them. Very importantly, they will check whether have you transferred the information. Have you communicated the fact to them that you want some sort of advice or some sort of approval from them on time or within the time frame or something like that. They don't check whether you use letter, whether you use some sort of mail, or whether you use WhatsApp communication. They don't check it, but they do check whether have you communicated through any media but proper information. So that's what they do check. So in terms of that one, they do check the substance of the message has nevertheless been communicated. They don't check about the medium that you have used or the mode that you have transferred the communication. They're very important that you need to remember. You need to communicate and transfer to them. So I remember while I was working for one of the projects, we had a problem. We identified one of the very riskiest problem in terms of cost and time. So what we did, we recorded that within our progress meeting. We did not issue notices and everything. Later, the parties raised that as a mediation, raised the problem to mediation. So the mediator, she is one of the famous mediator. She came here and she checked the document, and the employer wrote an argument, and they say that the contractor did not issue proper notice. But the mediator asked as a counter question, have you aware about this? Have they notified to you by any mode or any medium about this problem? Then they said, yes, we have recorded within one of our progress meeting. It means that we have transferred the information or the problem to the other party. It means simply they are aware about it. So most of the countries, judicial or law, they don't look into that. They don't look into that, but they look whether have you transferred the information to other parties or not. And the next one that we are going to learn, why notices are important. Why? You can see here, in order to make aware of the employer, of course, that is a very big reason, but the awareness that you are going to make in terms of requesting approval, or maybe you're going to request them to provide some sort of actions, or you may request them to give some sort of additional information, or maybe you are going to inform them that I may incur additional cost and time, and there will be a problem. There will be a problem. So the very important of the notice is to make or alert other party and make them aware to take a decision. For example, in one of the projects which I work, the employer issued one omission notice. Then when they issue the omission notice, the contractor suddenly replied to them and informed that we have a so-and-so cost impact as we have already executed certain work. Then suddenly the employer identified they initially planned to do this work with some other parties. Okay, it is provisional sum, they omitted. So they plan to do with the other parties. But unfortunately, this client team, they have already raised and asked the contractor to do the work through informal communication, something like they sent through an email, they attach one advanced copy of the drawing, and they asked them to do the work. Now, suddenly they have issued omission works, and the contractor came back and said that, dear contractor, dear client, we have requested us to omit this work, but unfortunately, as we have previously requested to do or execute some sort of work, considering advanced copy, we have so and so cost. Suddenly, the employer issued another instruction to withdraw that omission, because they have identified the contractor gonna claim additional amount of money that's for the work that they have already executed. If they're going to award this work to someone else, they're gonna claim additional money for the work already the contractor already executed. So in order to avoid that, they made the decision and they revoked this notice, revoke this omission, and the instructor to continue the work further. So very important, notifying through notices will give a chance for other parties, whoever the parties, to take a decision as well as to take some sort of good advantages, good benefit. Yeah, they're going to serve money. Other parties will have a good understanding. There wouldn't be any, some sort of friction between the parties. The project will move good. So early warning, it's not going to be early warning, right? It's not an early warning. Notices are not to early warning. It's not something that you are going to issue under clause 8.3. So where it says that if you have identified any problem to your program, you need to issue notices. No, that's early warning. But notices are something making alert them, telling them that I have so and so consequences. Yeah. So notices under FIDIC, Red Book, except Gold Book, they did not define notices. Now, under 2017, they made notices with a capital N. 1999, 87, everything with simple N. So you need to make sure that most of the time, the employer, they try to remove these notices from the clause. For example, a couple of days ago, I had a chat with one of my students where he said that the employer specifically remove one clause which say that the contractor can raise any dispute through notices under 60.7 or 67.1 of FIDIC 87, which say that the contractor can raise any dispute through notices. The employer specifically removed that. Yeah, so you need to make sure if you are going to define some sort of word, of course, you need to include certain thing within that, and you need to make sure that that will be implemented. And also, it's not fair. It's not fair removing clause which is going to give other party a chance to raise their dispute or their problems or any other concern. So you need to make sure that you will include within that, and you will be fair. And you can see here, as I have mentioned, one of the notice being used for one of the projects that they mentioned they have requested something from the engineer. They issue notice and they have requested something from the engineer. So they requesting. So notices you can use for the purpose of many things, including actions, any actions required. For example, while I was working one of the airport in KSA, we have requested action. We requested them to remove some sort of medications they have place in one certain place because we want to start some work. We inform them, we should notice to them, and we inform if you don't remove that within so and so days, we will incur additional time impact. So we requested them to do some sort of action. So as I have mentioned here, FIDIC says you can issue notices for all these purposes. All these purposes. The next one that we are going to learn, time frame for notices. Of course, in most of the situation, the contract says a very specific time frame. Very specific time frame. Of course, I know that one. Your contract also telling you not to miss the time frame. Can anyone tell me how you are managing your notices without missing the time frame? What is the method that you are using, or how you are managing not to miss the time frame? For example, you have identified one problem and your contract say that you need to issue notices within certain days. You need to issue claim interim. If it is interim claim, very first claim is going to be interim claim within so and so days. Then next one is going to be next interim claim within so and so days. So how you all are managing? Can you please type how you are managing? Maybe what is the tool that you are using? Now, I mean, what tool that you are using to manage those things? Very good. Very good. I can see a couple of yes. Very good. All your answers are correct. Of course, normally normally the very basic thing that we do, maintain log. Of course, we do include all those notices and everything within our reports, but we do have a log to manage them. For an example, today I have identified, for an example, okay, I have identified through shop drawing, the employer highlighted and instructed me to do additional work. Then what I'm going to do immediately, based on my contract, I'm going to issue notice to the employer. Dear employer, you have requested us to do so-and-so work through so-and-so number of shop drawing. We anticipate or we forecast this change will incur additional cost and time to me. Therefore, please provide me an official instruction, or please instruct me through an official channel to execute this work. So today I have identified what contract say that within 28 days or whatever it is that you need to issue a notice. So what I'm going to do is I'm going to simply prepare a log. I'm going to put notice number 10. This is the subject. We have identified the event on this date, and we have issued notice on this date. And the contract say that we need to issue interim claim or whatever the final claim within so and so day. The event we got to know on this date. So from that 23 days or 28 days or 53 days, whatever the days that you're going to end, and you're going to highlight the date when you need to, what is the final date that you need to issue your claim. So it's a very good practice to have a log in order to manage it. It is one of the important things that if you are following FIDIC, FIDIC is one of the very strict thing. It is telling you if you fail one of your submission day or submission time frame, then you are not entitled. We are going to see that one. So it's a very good practice to make sure or maintain a log mentioning when you got to know about the problem, when you have issued notices, and when you're supposed to issue your claim, and when you are going to submit those things, and what is the status, whether the employer issue engineer instruction or have you agreed with the employers or not, like that. You need to mention that. And very important thing that you need to make sure that you are following log regularly. I mean, every day you need to check it. As long as you have a person to check that, you will not miss the chance to fail or miss the chance to fail. So when you raise a notice within the time frame, the main reason is to alert them. So they can take action, and they will come back to you and give you some sort of additional instruction. And the next one that we are going to learn, these are the time frame of notices based on the FIDIC. FIDIC says many places, as soon as possible, you need to issue. And some places it says that not less than 28 days, or maybe not later than 53 days after the contractor became aware or should have become aware of the event or circumstance. It's very careful, guys. You need to be very careful in all situations. As a common theory that you need to take home today, that you need to issue notice as soon as possible, but within the time frame. As soon as possible within the time frame, because it's very clear. You can see here the FIDIC says that so and so days after the contractor became aware or should have become aware. So this one is very critical sentence. They have mentioned one sentence where they are telling that you should have known this problem on this date. For an example, a simple example I tell you. In one of my projects which I'm working now, the contractor started to dump, I would say that stockpile crushed material in one location which is not approved by the employer. Employer very clearly says within the contract that you need to stockpile all the crushed material within the zone 1. But because of two contractors working with the main contractors, two subcontractors, crushing subcontractors working for the contractor, they want to make a quantification. They want to check which contractor made what quantity, which contractor made what quantity. So they allocated two location. Now they are quantifying each location's quantities, and they are paying to them. Now the employee's requirement is to dump or stock the material in one specific location. So after a couple of months, almost they have completed their crushing, and they are trying to claim from the employer and telling the employer, because of so and so problem, we stockpile the material somewhere else. Now we need to mobilize that material to zone 1 or zone A, and for that we are going to incur additional cost. The very first rejection the employer made to them, very first, that if you are going to raise any notice, you should have, you should know at the time of, starting stockpile some other zone, you as an experienced contractor aware that you need to mobilize this material to zone A, which will cost you. You are claiming now after 6 months or 4 months that you will incur additional cost, which is wrong, because you should have become aware, or you should have become about this problem 6 months before. Why you are claiming now? And the second one they mentioned, the employer requirement says very clearly to you that you need to stockpile this material within the zone A. Why or who asked you to stockpile the material somewhere else? So you need to be very careful, guys. The FIDIC, if the employer did not remove this clause, remove this information, you need to be very careful. If you got to know some sort of problem from any of the project work, then immediately you need to notify to them. Don't wait until you incur some sort of cost. You need to immediately inform to them. So even though the FIDIC says many places, many days, you need to inform them, notify them as soon as possible, but within the time frame. Of course, don't wait until 28 days. Don't wait until 53 days. Inform them, notify them as soon as possible. That will help you in terms of giving you a response, receiving response. For example, you are telling that you have a program impact of 20 days. If you are going to inform them at very last day, telling them I have a program impact from tomorrow, it's not a proper way. You should have informed them way early for them to take a decision. So they can change their decision, they can withdraw their instruction, they can ask you to follow the program. So if you are going to inform them within a very short period, within a very short margin, and immediate, or very close to your time, then that will be a problem. So FIDIC explanations, most of the genius, what they are telling that even though you have a time frame, you have a certain days, you need to inform them as soon as possible, but within the time frame. Okay, so that's what I have mentioned, that as a best industrial practice, regardless of the law that your contract formatted, it's advisable to issue notices within the stipulated time or as soon as possible. So you need to make sure always that you are going to issue to them, and make sure your notices are not early warnings. Your notices are, you are telling them you need some sort of action or you are entitled for something. So make sure that you are going to raise some sort of consent which is going to benefit both parties. It's not some sort of early warning. So you need to be very careful. And the next one that we are going to learn, it's about content and formalities of the notices. Of course, you need to make sure your contract notices should incorporate many information. Something very first, it should be on your letterhead. You need to use your letterhead, not something like empty pages. You need to it's very good practice to use your letterhead. And the second one, you need to mention the date. You can see here, I have copied one of the actual notice. So you can see the date, the letterhead, the letter number, notice subjects, what is the project, what is the notice number, under which clause you are issuing, and detail of your notice, what scenario made you to raise or inform this notice, and what clause, under which clause that you are entitled, giving them a small explanation. And normally notices should not be more than single page or 2 pages. It should not be more than 2 pages. If you are going more than 2 pages, you are not capable enough to explain enough information under notices. The FIDIC very clearly says you need to give notice. You don't want to give them information. And in terms of information, mean detailed information. That's why they are giving you chance again. You need to submit your full particulars, all the particulars within another 28 days, or maybe another 55 days or 54 days. So they are initially telling you to raise a warning, raise the alarm to them in terms of cost, actions, or anything required. Then later collect all the information and submit to them. But your early notices should be with certain information, something like subject, under which clause that you are entitled, and why you are issuing, what is the event made you to raise that. All this information that you need to mention. Authorized person signature is very important. Of course, I have received one notice. I remember while I was working for Thai Airport, I have received one notice from one of the nominated subcontractor without the person's signature. Then I asked him whether it is from the authorized person or maybe someone, break your system and issued notice to us. We don't know. And there should be authorized person signature. He should vet his signature in there. So we requested them to reissue that. Then they took another 4 days because that person, he's from some other countries. So they sent the document, he signed that and issued that to us. Because he was on vacation, they issued without signature. So you need to be very careful. You need to make sure that you are issuing document with the signatures, including all this information that I have listed here. So normally, most of the time we do include all those things. But one thing we very often miss. If you are going to issue notices, before you crystallize this dispute or problem, you might have discussed these issue through many other documents. Maybe you might have issued letter, or you might have discussed with the minutes or meetings. You might have mentioned that within your progress report. Rather than giving a bare or blind information to the parties, it's better to mention references and mention all the previous document which is speaking about these things, or which are speaking about these kind of problem, and list them down. That will give a quick access to other party to access the document and take quick action. Otherwise, they need to go back and they need to revise and discuss with that, and they're going to reply to you without checking one document. Then you are going to reply to them, please check that document. So it's going to waste of time. In order to avoid that, when you issue notice, you need to mention all your previous letters or documents, communications, email dated from whom to whom, and mention them and attach those documents if possible. It's not requirement, but you can attach them. So when you draft your notices, you need to be very careful that you are giving early awareness to the parties and are telling them you need some sort of action or you will incur some sort of problem. So you need to be very careful in that. And the next one that we are going to learn about, when you are issuing copies of notices, as I said earlier, when you as a client or as a contractor or as an engineer, when you issue notices, normally contractor will issue notices to the employer and will copy the engineer. And the engineer or the employer, they will issue notices to the contractor. But as a contractor, you can't issue notices to the engineer. Why? Because you have no contract with them. You are not a person who is controlling them, but they are controlling your projects. So it's very simple mechanism from the FIDIC that you can extract. FIDIC says that you can issue notices to the employer, not to the engineer, unless otherwise your contract very specifically say that you can issue notices, or you need to send, or you need to direct the notices to the engineer, copying or heading their name. Unless otherwise, you need to issue the notice to the employer, not to the engineer, if you are a contractor. But if you are a consultant, of course, you're going to be a neutral person. You will be contract administrator, and you can issue notices for both parties. And of course, employer, they have a contract or they are controlling these people, so they can issue notices for contractor as well as engineer. So this is very simple mechanism. And also, most of the time, we do fail, or the contractor, they do fail to issue notices. They are the one most of the time incur time and cost. So they should be very, very careful in terms of issuing notices. So why they do fail? The very important thing is they have no knowledge. For example, I'm working for one of the projects, so I have issued one contract administrator's instruction to the contractor. Then I have a log. So I check the log we have already passed the day that the employer or the contractor should issue notice to us in terms of whether they have cost impact or time impact to the contract administrator instruction or not. But they did not issue. Then I phoned the guy and I asked him, why you did not issue notice? Then he said, then why do we need to issue notice? He simply asked, why do we need to issue the notice? Then I said that we have issued engineer instruction. We don't know whether as a contractor, whether you have cost or time impact or not, we don't know. We don't know. Of course, we did our internal work and we know that one, what kind of impact it may incur. But as a contractor, we don't know what kind of loophole you made within your BOQ or what in your submission. And we want to hear from you whether you have impact or not. Contract simply say in any situations or in any document instructing you and you are forecasting that will incur additional cost and time, then you need to issue notice within 28 days. So why you did not issue? Then suddenly he argued with me and said that no, if it is a contract administrator instruction, we don't want to issue notice. And then I said, just simply prove me that you have no cost and time impact. If you have, the contract very clearly say that you need to issue notices. So the very basic reason that they have no knowledge, or maybe they have no competent person to handle it. So previously I worked one of the airport, not in Saudi, other country. So while I was working for that, we were not able to manage issuing notices because the project was so very big and we got no enough staffs to handle these kind of notices, because the employer very often they do ask us to do additional work through RFI or shop drawings or maybe meetings. They do just ask you to do some additional work. We need a person, a competent person to catch all these things and raise that as a notice or as an additional work to the employer. But we got no competent or enough staffs to do that one. That's will also one of the reasons. And the next one, we know that one, the contractor might have priced you very high. They price with very high. So because of that, they think that, okay, this work, this additional instruction gonna cost us nothing. We don't want to consider that. Casually, no problem, leave that. Yeah, most of the time, of course, the contractor missed to price additional item. For an example, the contractor will be provided very certain time. For a big projects, 3 months for them to submit their tender, BOQ and everything. So they will have a very limited time. So they price this item based on the BOQ mainly, and very rarely they do cross-check with specifications or other things. So what they do price the BOQ without checking the specification quickly. So for one of the projects, what they did, they price it without checking the specification. In the BOQ, they mentioned the contractor should provide one lump sum item, vehicle. Within the specification, they mentioned they need to provide, for an example, 10 vehicle. But here they mentioned one lump sum, the contractor price without checking the specification, 5,000 riyal. And when they started the projects, the employer requested to deliver 10 vehicles, and the contractor said that, why do we need to deliver 10 vehicles? In the contract, it say 1. Then, based on the president's order, the employer replied to them, say that the employer's requirements say 10 documents, 10 vehicle. Even though BOK say 1, you should have a price for 10 vehicles. So mostly the contractors make mistake. Because of this kind of mistake, what they do add enough margin with their cost price. They have identified the tender going to be something like 100 million. They will add around 10 to 12% as a margin of error and omission. So because of that one, they will think, okay, we have received very less changes, valuably, let's do for the purpose of our side. Okay, so normally you need to make sure those kind of thing also. And the next one we are going to see, communication must not be unreasonably withheld. Of course, if you are consultant, of course you should not delay the approval of the document or reply to the contractor's request. There are two things within the FIDIC. One, must not be reasonably withheld. It is suggested more fundamental and governance the decision making process itself. It means that, for an example, you need to take a decision whether you need to give approval or not. Some situation, the contractor, they do ask you to provide you a approval where, based on the contract, you don't want to give approval to them. You don't want to give approval to them. So when you receive such a document, you simply need to inform to them, maybe informal way or maybe through meetings or something like that. You need to inform to them that I'm not going to reply because this is not contractually required. So you need to mention that. The next one, it's simply say that must not be unreasonably withheld. You should not suspend any document. It is unlikely that a person would be able to withhold any of the things that he doesn't like. For example, one of the method statement, the supervision consultant received, which is not in accordance with his expectation, not with his expectation. So he cannot tell that I don't like it, because of that one I'm not going to give approval. So what he needs to do, he needs to reply to them. At least he needs to give code C and tell them, please incorporate so and so information. I don't like it, because of that one I'm not going to give approval. You can't tell them. So you need to tell them, reply to them. So unreasonably, which is not acceptable reason, you should not withhold them. The second one is, the FIDIC say that you must not unreasonably delay. It means that your contract says that, for example, my contract says that the employer should give approval for any of the shop drawing within 14 days. For example, I have received one of the shop drawing. For it, I need a designer's approval. My designer's in, for example, vacation, or maybe because of some other situations, I cannot communicate with them, and the internet medium did not work properly, or my communication system made problem to me. So because of those kind of things, I got no time, or I took a couple of more days to approve those things. In these kind of situations, you should not consider the contract as a contractor. You should not consider these things as a unreasonable return. It is not unreasonable, of course, because of some acceptable reason he suspended his approval. The contract very clearly says that within how many days that you need to give approval. If you are going to delay more than that, at least you need to give them a hint that your document under so and so progress, we will answer you within so and so days. So when you receive notices or any other document related to that, you need to be very careful, and you need to inform to them within a proper way, and you should not suspend them without unreasonable conditions. And the next one we are going to learn, failure to comply with the time frame, simply time bar. Of course, in the contract, normally they do say that you need to issue notices within so and so days. So if I fail to issue that, is that going to be a problem to me? Give your answers, type your answers. Is that going to be a problem to me if I fail? Okay. Yes, 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 very good. Okay. Anyone going to tell no? Very good. Okay, I have received everything as a yes. Of course, yes. Very basic thing that the way that your contract drafted. Most of the time, of course, the contract says that if you are not going to deliver the things, or if you are not going to inform me within 28 days, then you are not entitled, or as a client, I'm not obliged to do anything. I'm leaving from any of my obligation. So it's going to tell them you need to submit within so and so days. If you don't, you will not get any benefit. What is the reason of that? The main reason of that, to make sure that because of this period, the contractor, the client might have schedules something related to this date. For an example, I'm going to tell the contractor, if you have any cost or time related things, you need to give me 28 days advance notices. It means that you need to raise that before you incur any cost. Within 28 days, you need to inform me that you will have a cost and time impact. Then I can go back to my stakeholders and say that, guys, because of this instruction, we're going to incur additional cost of 1 million. Are we able to bring the money? Can we collect that money to handle this problem? Then we can identify within that 28 days, we can identify whether it is collectible money or not. Then we can inform the contractor, okay, go ahead. If not, then that's going to be a problem. So the main reason that to make alert the parties and get the benefit. But top of your express term, top of your contract, you need to check your country law. You need to check your country law, because most of the time the country laws is the one going to overrule all your problem. Even though you have expressly mentioned something within your contract, that may overcome and that may make some sort of adjustment or changes to your contract too. So in that term, if you take time bar under GCC, Arab nation, they are telling that it's not no more valid. It's not valid. If you take KSA Sharia law, they have mentioned that if you are going to incur additional cost, or for the work that you have already executed, you have incurred cost, you should be paid. And they are giving different time frame. For example, if you take Egypt, they are giving a time frame for the party to notify longer than the FIDIC. If your FIDIC says 28 days and the contractor issued notice after 35 days, and you can't argue with them that you are not entitled. Of course, based on your contract, they are not entitled, but under the governing law, if they raise a concern to the court or the litigation, then the court will rule, yes, they have issued the notice within the time frame mentioned within the law. So under common law, mostly the judges are, common law means Western part, yeah, common law means which is being followed throughout the centuries. So under the common law countries, if your contract very clearly say that you need to submit your notice within so and so date, if not, you are not entitled for anything. If you are going to mention that very clearly, then the parties cannot get their entitlement. But if you don't mention, you just mention you need to submit your notice within 28 days, the country law and the courts will look into that as a mostly as a what? As a, anyone can tell what is that? It's going to be. No, I'm asking that if you do not have a consequence of failure to submit notices within this date, you did not mention. Okay, so in the contract, if you did not mention the consequence of failure to submit the notice within certain days, then the court will take it as a directory rather than mandatory. If you have mentioned two items, something like you need to submit the notice within 28 days. If not, you are not entitled for anything. If you mention these two information, then that will be considered by the court as a mandatory. If you did not mention, if you don't mention, you just mention the contractor in any case, cost of time, he should submit notice within 28 days. And you did not mention if you fail, then that will not give any benefit. Then that's going to be as a directory. It means some sort of suggestion. You need to submit within 28 days. Otherwise, you need to take more days. That's what it says. Okay. So most of the time, if you did not mention the second paragraph under the common law, that will be considered as a direction, yes, suggestion rather than mandatory. But under GCCs, based on the considering the country law, that will be considered as an invalid option, because most of the time the country laws, they are telling that you're entitled to claim whatever the cost that you have incurred, or most of the countries time frame are more than the FIDIC time frame. Okay. So these are the major items that we need to learn about the notices under FIDIC. So with that, I hope that I have delivered all the major information. And thank you so much for your patience as well as attendance. You can ask any questions if you have through chat, please. I'm going to give around 5 to 10 minutes to answer the questions related to notices, not related to claims. Of course, if time permits, next time we will look into the claims on the FIDIC. Of course, previously we have seen EOT. We have checked, we learn about EOT, and still the video is available, and the YouTube, you can look into that. Yes, Silva, of course, you mentioned it depends on the contract. If any other clauses where your employer mentioned that you need to submit, otherwise you will miss it. It is a condition precedent. In order to get your entitlement, you should have submitted within so and so days. Not only under 20.1 or whatever the clauses, but in any other clauses, if your employer mentioned you need to submit your notices within so and so days, otherwise you will lose your entitlement. It means that it is a precondition. You need to fulfill this condition to get your benefit. So it is a condition precedent. Normally, the employer, they do keep that, and they do introduce that condition precedent for other clauses too. So you need to be very careful. Of course, it depends on the contract. The employer and the engineer they are inside. The engineer attended weekly meetings and lot of reports being submitted by the contractor. Employer and the engineer know top and bottom of the project, still why FIDIC require notices. I did not get your question, Rajesh. If you're asking that they do submit lot of reports, and the engineers and the employees are top and bottom of the projects, still why FIDIC requires notices? You mean you're asking, okay, they are issuing reports, and why we need FIDIC and notices, yeah? So it means that reports are not, it's not a formal informations just for one incident. So we need a notices to notify to the parties specifically on that occasion or about a single event. When you are submitting your reports, of course, in that you are going to mention collective of information. And also that's going to be at the end of the month. But this notice is going to be whenever you incur problems, whenever you face problems. So it's going to be instant, not going to be at the end of the time. Whether WhatsApp can be considered as a mode of communication for notices. Akbar, of course, it depends on the parties. Of course, if you have a certain protocol that any electronic media can be considered as a notices, of course it can be. But normally I never heard that they do consider WhatsApp as a notices. For that, at least they do ask email, but not through chatting application or something like that. Because these kind of application anyone can operate. Without your knowledge, anyone can operate. But when you use emails, Of course, that will be only from you, and also that will be through, if it is a letter or something like that, that's going to be through Econics. So that will be official mode of communication. I never heard, but it depends on your contract. The other one, as you mentioned, we can based on letter considering notices. Is this common practice in Qatar? Well, I don't get your question. As you mentioned, we can based on letter considering notices. Is this covered? Yes, I mean, without mentioning notice under so and so, yes, you can. You don't want to mention notice under so and so within the subject, but within the letter, you need to mention at least to give rise. As I said earlier, if you are going to issue just a letter without telling them under which clause you are claiming, what you are claiming, you're just telling them, the employer, I'm entitled for cost and money because of so and so condition, so and so problem. The employer, they have no idea under which clause you are claiming. Then they need to go back and check their contract. It will take long procedures. Even the FIDIC did not ask you, FIDIC, they don't ask you to mention clauses except 20.4. It's a good practice to mention. But if you are going to issue a letter, just a letter, of course, later you can go and argue, but that will be difficult for you to mention them. For this purpose only, I have raised this letter. It's going to be very hard. That's why, as I said earlier, very importantly, employer in almost all the contract that you mentioned, you need to mention under which clause that you are raising your notices. For example, I have worked with FIDIC contract throughout many projects. All the places they have mentioned, you need to mention, if you are going to issue notices, you need to mention under which clause that you are raising. If the contractor considers himself to be entitled to any extension of time for completion and/or any additional payment under any clause of this condition or otherwise in connection with the contract, the contractor shall give notice to the engineer describing the event or circumstance giving rise to the claim, not limited to EOT claims. Yes, you're right. Not limited to EOT claim, but anything if he considered, he can raise. But specific, they have mentioned under 20.1, if you have EOT, then you need to raise a notice and you need to mention that notice that you are raising under so and so clause. The employer wants to change the contract from FIDIC 87 to FIDIC 99 after the word of the contract. What is your advice? What are the risks to the employer? You mean they want to change? They have already signed the contract based on 87. Now they want to change under the 99. Of course, it's completely different. They have more than 60, 70, 80, or your employer might have changed it to 80, 90 clauses. Now, if you take 99 with the very, succinct information, and that's with 20 clauses, that will be a problem. You should have considered this at early stage. Otherwise, that will make many problems. When you change from one contract to any contract, another contract, the contractor will focus 100 of risks. Yeah, he will focus 100 of risk. From your 87 contract, he might have considered 100 of risk and price your contract. Now, if you are going to change at the middle of the project, of course, again, they will price it. And that will be a mess. So you should not practice these kind of things. The employer wants to change the contract from FIDIC 87 to, okay, that's fine. Thank you so much to all. Please follow Arab country mandatory. As I said earlier, in the Arab country, it's going to be directory. Of course, most of the time that will be invalidated because your law is telling something completely different than your contract. That will tell you it's something like directory. It is directing the people that you need to submit the notice, but it's okay if you can submit within certain days. It's not going to be mandatory. Mandatory means even though you mention the second clause, it's not going to be mandatory. The 28 days or whatever the days, it's going to be overruled by the law. The contractor can give, should give notice to individual or can submit all events under one notice. It depends on the contract. You need to check your contract, whether your contract allows or not. And very first, second thing, That is the very first thing. The second thing, of course, you have identified 5 events within 28 days. Then you can raise all those events under one notice, no problem. And you can use that notice to submit all your claims as a global claims or combined claims or whatever it is for all those 5 items. That's not a problem. But make sure that you are going to obey or comply with the express term of your contract. Ravind, to go to seek solution on common law, don't we need to follow that arbitration process at first? No, common law mean the common law. It's mean the country law. The country where we live, GCC, they have a Sharia or civil Sharia mixed law. It's not a common law. Common law mean, I need to explain this one from basic. Common law mean the law which is being followed since long time ago. The court, they do make a law. Those law and the decisions will be followed for future regulations, future, decisions. It is common law. Common law means it's a one law, a court decided that will be followed throughout the period. Simply. Yeah, we don't want to go deep. Civil law means that will be prepared as well as instructed, or maybe that will be released by Parliament, mostly. Yeah, that will be code, civil code 1, 2, 3, or section 1, 2, 3, something like that. These are the 2 laws. Sharia law, it's based on Quran, and another one, Hadith. It's based on the Prophet Muhammad sallallahu alaihi wasallam guidance and the Quran. So based on that one. So there are 3 kind of things. One is common law. It's basically a simple information that I'm explaining to you that is following since very long time. They are following single law and they are making small changes as they want. And the civil law, it is commonly for these kind of countries, Sri Lanka, India, many other countries, they do follow. The law will be released by the court boss, will be Parliament. And the next one is Sharia. It's based on the Quran and the Hadith. And then for your question, of course, no. DAB, you can follow anywhere. You don't want to go first DAB. If you want to go common law, you don't want to follow. No. DAB is some kind of dispute adjudication board. Whatever your country law, no problem. But you can have a DAB, internal dispute adjudication board, you can have. Fayaz are saying, what is the situation deviating notice of variation, notice of claim? I don't understand your question properly. If I'm not wrong, you're asking whether these variation notices and claim notices are different or something like that. From my understanding, what I'm telling that regardless whether it is variation or maybe any other situations, if you are going to incur cost and time, mostly the FIDIC contracts say that you need to raise a notice. The notice can be notice of variation or notice of claim, but at the end, you're going to incur cost and time. So you need to raise a notice of variation. You need to raise a notice of the claim. At the end, you are going to entitle for cost and time. So almost both of them are same. If it is not specifically mentioned as a notice from the contractor side to the engineer, who matter is included in many letters, where the contractor is entitled for your. Yes, Femi, on the contract, very specific. If you haven't changed your contract as employer wants, but it is similar to FIDIC 1999, of course, only one situation, FIDIC says the contractor should mention under which clause they are issuing under 20.4. If they did not mention, but they have communicated the proper information to the other party, of course, they are entitled for the things. But for the EOT, make sure that your contract very clearly telling that you don't want to mention it. Something it's telling that you need to issue a notice. If you are entitled for extension of time, that's fine. You can issue letter. You just need to mention notices. But you need to mention specifically under what clause if your contract saying that. If your contract is saying that, you need to mention it. So many questions, guys. Let me pick a couple of questions because we have very limited time. So let me pick very important. Pradesh, you have asked a question as a general practice. Why are we sending notices to the engineer? It's not a wrong practice. It's based on your contract, but it's a very common understanding. We all can see, we all can think that the contractual parties are these two parties, contractors and employers. If you are entitled for money, that money from employer only. Money from employer only. You cannot claim money from the engineer. Engineer is just a contract administrator. He's going to administrate the contract. So you can't claim them. So that's why most of the contract is asking you to send a notice to the employer and copying them, because they are not entitled to it. They are here to manage all the things, not to respond anything related to cost and time. And also, employer is the one who can take a decision other than design issues and everything. They are the one who can take decision in terms of cost and time. Because of that one, most of the contract telling you to issue notices to the employer. But I don't know how your contract, if it is telling that you need to issue notices to the employer, to the engineer, it means that directly you need to issue and you need to follow them. It may be your party, your employer decided on in that way. Raj Kumar, of course, you asked one question, COVID as epidemic or pandemic. The people they got no aware, they have no knowledge whether it's going to be pandemic or not. So most of the time, of course, most of the time, after you got to know it is a pandemic, you need to raise your notice at least. You need to raise your notice at least, and you can claim that one. So that's why FIDIC say you became aware or should have become aware. If you became aware after their raise, after the country announced it as a pandemic, you got to know that this is going to be a problem for me, then at least you need to raise a notice. If your contract did not allow such a thing, you need to go back to the country law and check that. The country, most of the countries, after they have identified this is not going to be epidemic, that's going to be pandemic, then they have informed government contracts or the any other contracts based on the law, they are entitled to claim the money. So they can claim that. More than that, you can use unforeseen event. Yeah, you did not forecast this, you did not foresee this. So you can use that clause to claim your money also. It's a very good question, Aniska Paride. She asked, he asked in a notice, the word notice has to be there with a reference to the subclause. It's a very interesting question. Of course, you don't want to mention unless otherwise your contract very clearly say. One of the contract which I work, FIDIC 1999, which very clearly say that the contractor, the employer amended, the contractor should mention it as a notice. Should mention it as a notice. So it means that whenever you issue notices, you need to mention notice. This letter is going to be notices. And the two examples that I have shown to you very clearly mentioned notice under clause so and so. So you have to mention it very clearly. It depends on your contract and its clause. Balamurugan, you ask about issuing the engineer making changes through RFI, material submitted and everything. Of course, you need to raise your notice. Check your contract. If your contract is telling that you need to issue some sort of notices, whenever you got to know that there will be additional cost or time, you need to issue notices. If it is telling about that, then you need to issue notice definitely within the time frame mentioned in that. Okay. With that all, it's almost 8:55. Thank you so much for all your patience as well as present. And MEQS Middle East Quantity Surveyors, thank you so much for your wonderful arrangement. And thank you guys. Thank you ladies and gentlemen for your kindness as well as attendance. You can see this presentation in YouTube. They're going to share the link to you all, so you can get to know and answer that. Let's meet another chapter, another section in next time. Thank you so much. Have a nice day. Bye.